Can grandparents get visitation rights during hostile co-parenting? Have you ever wondered if grandparents can still see their grandchildren when the parents are not getting along? This is a common concern for many families. The good news is that grandparents can seek visitation rights even in these tough situations, but there are some important details to know. First, it is essential to understand that grandparents do not automatically have visitation rights. The ability to obtain these rights varies based on state laws and the unique circumstances of each family. Courts usually requiring that grandparents show how visitation would benefit the child's well-being and not interfere with the relationship between the child and their parents. Many states have laws that allow grandparents to petition for visitation under specific conditions. This often happens when the child's family situation is disrupted. Common reasons include the divorce or separation of the parents, the death of one or both parents, or if the child has lived with the grandparent for a significant amount of time, like 12 months or more. Additionally, if the parents are deemed unfit, or if there are exceptional circumstances, this can also qualify. In cases where co-parenting is hostile, and one parent is actively preventing the grandparents from seeing the child, the courts will closely examine the existing relationship between the grandparents and the grandchildren. They will look at factors like the emotional and physical well-being of the child, the strength of the bond with the grandparents, and whether visitation would disrupt the parent-child relationship. If the parents agree to grandparent visitation, formal court approval may not be necessary. However, in more contentious situations, grandparents usually need to file a petition with the court for a visitation order. Courts may requiring that grandparents first try to resolve the issue through mediation. When making decisions about visitation during hostile co-parenting, courts focus on whether visitation serves the child's best interests. They also consider the quality of the relationship between the grandparent and the grandchild, the potential impact on the child's relationship with their parents, and whether the parent's hostility is harming the child or unnecessarily limiting beneficial contact with the grandparents. It is important to note that grandparents may not be granted visitation if the parents have reconciled after a separation or divorce. Additionally, if visitation would significantly harm the parent-child relationship, courts will likely deny the request. If grandparents have had little involvement in the child's life, or if their visits would escalate family conflict, this could also lead to a denial. For grandparents facing these challenges, it is helpful to document their relationship with the child and any attempts made to maintain contact. Seeking legal advice early on and considering mediation can improve the chances of obtaining visitation. Courts may also grant supervised visitation or limited visitation schedules to balance the child's welfare with parental rights. In summary, while grandparents can seek visitation rights during hostile co-parenting, success depends on showing that such visitation benefits the child and does not interfere with parental rights. Courts carefully weigh these factors to ensure the child's best interests are protected.